Well, if you don't like a 9-0 ruling against you and you're the Trump administration, just lie about what the ruling says. Just misquote it back to the trial judge who's administering the case. That's what the Trump administration is doing as they continue to defy Judge Xinis' orders about Abrego Garcia and the case, more particularly her trying to get to the bottom of whether they're committing contempt by refusing to facilitate his release from an El Salvadoran prison, one of the El Salvadoran prisons. They're moving him around like a shell game. She's got the right, the Supreme Court says, to make sure that they are facilitating. The Trump administration refuses to give her those answers. She's assigned to the other side, the plaintiff's side, the duty, the right to go after the Trump administration and get answers. They need answers in discovery, in that process, in depositions, sworn statements under oath, Q&A style, in sworn written statements under oath, interrogatory style, and the Trump administration is not doing it, which led to a new filing in Judge Xinis' courtroom, which is not going to make her happy, and is probably going to lead to more sanctions against the Trump administration. But I can't believe that at the moment when they needed to recite accurately what the Supreme Court ruling against them was, they even got that wrong. I don't get much wrong. I'm almost never wrong. I'm here on Legal AF, and so are you. Listen, while we're here together, let's do something collectively as part of the fellowship, as part of our unity here. Hit the subscribe button. It really does help as we're continuing to grow. We're already adding about 2,000 subscribers per week. Amazing as we continue our march towards 1 million. And this is a great day to do it because our brother podcast, the Midas Touch podcast, just won the Oscar, the Webby, for Podcast of the Year. And, I want that award next year, by the way, for Legal AF. Now, here we are. Let's get back to the misstatements aplenty. How do we get here? 9-0 United States Supreme Court rules to support Judge Xinis and says everything about her order requiring that the Trump administration use all efforts to facilitate the release from an El Salvadoran prison of Armando Abrego Garcia was right. They completely support her. She issues a supplemental order that says you have to report to me every day at 5 o'clock what you're doing about that. And since then, the Trump administration hasn't not complied with her order at all. They keep telling her to go pound sand and other more colorful words effectively. Go legal AF yourself effectively, because they're just like, well, we'll tell you where he is. He's in this prison. No, we moved him to this prison, but we're not going to tell you what we're doing to facilitate, even though you've ordered us to do that. Even though the Supreme Court has ordered them to provide the judge with the steps they are taking, they're not doing it. They're claiming it's state secrets. What is the state secret about what you're doing diplomatically to bring him out? We know you're not doing anything. We saw Trump in his ridiculous scripted moment with the dictator of El Salvador, Bukele, in which they were like, this ridiculous horse and pony show. Oh, everybody, I'm not going to release him. I wouldn't smuggle a terrorist into the United States. I wouldn't ask him to do it. I mean, it's like ridiculous and silly. But here's the part of this hot take I wanted to bring out to you. They're lying about what the Supreme Court said. Here's what the Supreme Court said. Then I'll get to the letter that was just written, kind of a joint letter, but really from Armando Abrego Garcia's lawyers demanding and asking the court for a status conference, which she's going to grant this week, and then she's going to throw the book at the Trump administration. The Supreme Court ruling was only about a page and a half, 9-0 in favor of this judge. It said that, this is on page 2 of the order. Here he is. The order of Judge Xinis properly requires the government to, quote, facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as if it would have been had he not been improperly sent to El Salvador. Listen to this phrase. It's not that hard. It's only 6-7 words. Facilitate Abrego Garcia's release from custody in El Salvador. 7 words. And the Trump administration gets it wrong. They said, here's how they're trying to change the language of words they don't like in order to say they don't need to respond to the discovery that's outstanding. Here's what they say. You heard those words. Here we go. In their response to written questions required by the judge, they said, defendants object, this is the government, to answering the first question that was provided to them, required by the judge. because it's based on a false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Then they claim to quote the United States Supreme Court decision back to the judge. Parentheses, in the Abrego Garcia case, that defendants should, quote, take all available steps to facilitate the return of Abrego Garcia to the United States. That's not what the Supreme Court justices said. They said, the government is ordered to facilitate Abrego Garcia's release from custody. Exactly the question that was being asked. Here you go. If you don't, you disobey, you are in contempt, you refuse to comply, and then when all else fails, just change the wording of the order you don't like. What the legal AF is actually going on here? So that is one problem. So when they're not changing the terminology of the actual Supreme Court decision as if federal Judge Xinis or the other side wouldn't see it, they are then throwing up these ridiculous privileges that don't apply. State secret's privilege, but they don't do it right. They don't assert it properly. So they haven't given the government hasn't given Abrego Garcia's lawyers any real documents other than public filings. They haven't given them any real answers and depositions. Those are the questions and answers under oath, like you're in a courtroom. They've started, and the judge told the other side in her last order, if the government screws around with you in discovery, come back to me immediately, and I will sanction them. And that's where we are right now. So here is the new letter that just went to the judge as a prelude to the conference that she's going to be holding this week to throw the book at the Trump administration. It starts with, this is from the lawyers for Abrego Garcia, which just incidentally, I've said this before in some other hot takes, Quinn Emanuel is representing Abrego Garcia along with the ACLU. They're also the outside ethics counsel for the Trump organization. You do the math. All right, here we go. We write on behalf of plaintiffs in the above captioned matter to request the court hold a conference to address the government's failure to comply with this court's order requiring the government to, among other things, produce documents and respond to plaintiffs' interrogatories. On the eve of the first court-ordered deposition concerning the government's failure to comply with this court's orders, because that's what we're all about. Are they in contempt or not? The government responded to plaintiff's discovery request by producing nothing of substance. Its document production consists entirely of public filings from the docket, copies of plaintiff's own discovery requests and correspondence, and 2 non-substantive cover emails transmitting declarations that were already filed in this case. Its interrogatories, those are the questions and answers under oath, responses are similarly non-responsive. The discovery responses defendants served this afternoon established that the government intends to prevent plaintiffs from developing the discovery ordered by this court to support their motion for contempt. And then they go through the reason how they're doing it. First, and this is the one about if you don't like what a Supreme Court ruling says, just change the words. The government artificially narrows the court's order to avoid complying with its obligations. For example, the government refuses to respond to interrogatories it claims are, quote, based on the false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Despite the Supreme Court's clear holding that, quote, the order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador. And they won't provide any other information. Now, the government, after saying we have the right to privileges and all this other stuff, and the privileges have not been properly asserted here, they then, because you have to do like a joint letter, you have to include the government's position at the bottom, which you can't edit. I've done joint letters before to federal courts. You know, you'd love to edit it. Like, that's not true, what you're saying in there, but it's their advocacy. And if they want to lie to the judge, subject to ethics violations, they can, pursuant to their bar license. Here's how they respond. As an initial matter, the defendants have, in all respects, and in light of the expedited nature of this discovery, put forward a good faith effort to provide appropriate responses to the interrogatories and requests for production. And it goes downhill from there. That indicates to me they don't have any intention, as the media has been reporting, in properly responding to any of this, and they continue to flout the orders of the court and try to obstruct justice. That's what they are doing. When you have your Department of Justice obstructing justice, you're in a bad place as a government. So here's what I think is going to happen. Here's what I know is going to happen. Judge is going to hold a status conference. Judge is going to issue an order after listening to the government. She's not going to like their interrogatory responses. She's not going to like their request to produce responses. She's going to fine them tens of thousands of dollars a day, or she's going to give the other side more discovery, more depositions in order to get to the bottom of this. She's going to put them on a tight deadline. She's going to make certain depositions take place, maybe even under her own supervision, or she's going to appoint a special master, which is an officer of the court, responds to the judge, to sit in the room during the depositions and to respond to any of these objections that may come up. If I were her, I'd step off the bench and supervise the depositions themselves. And then, so right there, when they get into a snit because the government's not responding, well, I instruct the witness not to answer. Judge makes a ruling on the spot, boom, and the answer is there. I get the Trump administration doesn't like Judge Xinis, doesn't think her orders need to be abided by, but they do. And the Supreme Court said it 9-0. One panel of the Fourth Circuit Court of Appeals said it 3-0. And Judge Wilkinson-led panel just 3 days ago, said another 3-0, all supporting Judge Xinis. And the rule of law and due process and the orders of the Supreme Court. I mean, Donald Trump is putting the Supreme Court in a terrible position. And he needs all the votes he can get. He loses Roberts. He loses Amy Coney Barrett on key issues about the administration. You can kiss the Supreme Court goodbye if you're Donald Trump. And he's rapidly heading that way to a deeply skeptical Supreme Court. I mean, he just came out. I'll do a separate hot take on this. Donald Trump just came out with a new social media posting on the Monday after Pope Francis died, or on the Monday Pope Francis died, actually, and said out loud, we can't afford to give everybody due process that we're going to send to jail. It would be really difficult. That is the fundamental precept of our constitutional republic and of our Fifth Amendment privilege. I know Donald Trump has a very weird version of the Constitution. It only has one thing in it, Article 2, the president's power. But that's not our Constitution. That's not the delicate balance. That's not the checks and balance. And that's not the separation of power. And I know all of MAGA has that same version in their back pocket. Can I see your Constitution, please? I'd like to compare it to the real Constitution, because there are other articles there, like Article 1 power of Congress, like Article 3 power of the federal government, of the federal courts. Yeah, like the Bill of Rights, like the Fifth Amendment, like the First Amendment. I think when you pull out the Constitution for MAGA and Donald Trump, it only has two things in it. I'll say two things. I'll give him credit. Article 2 and the Second Amendment. They're into twos. That's all there is. Second Amendment, right to bear arms, and the power of the presidency. I don't know what country that is that you've just described, but it's not my America. And it's not the United States of America of people here on Legal AF. Look, take a moment. It's important. Now more than ever, break the glass. It's the emergency. We're the foot soldiers for the Constitution. Hit that subscribe button. We're doing now 2,000, 3,000 subscribers a day, which we need in order to fuel what we're doing here on Legal AF. We got about a dozen contributors. We're doing a dozen videos a day. I'm bringing on new contributors. Signal to me you want me to continue to add on new voices, new contributors right here on Legal AF by hitting the subscribe button. Till my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.